Hello, I'm Advocate Jayashree. Today we will be speaking about property. The word property itself strikes a chord in all our minds. Why? That's because properties always have the tendency to make relationship or mar relationships. Usually it is between the familial relations, that we get caught. We don't know who will benefit from what, right? So we want ourselves also to be benefited, others also to be benefited. So we are at a loss to know which is the best way to transfer property, especially when it comes to familial relationship. If it is between strangers, that's not a problem with us, right? So between strangers, we just give the property to them by way of sale, and then the other person purchases, or we just gift it to the other person. Some of them, they give it as a charitable trust. They give it off to the charitable trust. So even in all these cases, if it is between strangers, it is easier. When it comes to familial relationships, it's tough, right? Because again, it depends upon the relationship among the family members, right? So let us just analyze a few ways of transfer of property today. Okay, first what I would like to take up is the relinquishment deed, or it is also commonly known as release deed. So what is release? What do you mean by relinquish? Relinquish means we are leaving it. We are leaving it out. So what are we quitting? What are we trying to quit? We are trying to quit the rights over the property. If I don't have any interest in the property, say it's a very big plot of land, or it's a very small share in the very big plot of land, or it's an apartment, whatever it is, whether we are the sole owners or whether we are the co-owners, doesn't matter in this case. But if I am interested in letting go of my share in the property, my right over the share in the property, then I might as well get a release deed done, relinquishment deed done, right? So what I can do, I can just go to the sub-register office and get the relinquishment deeds registered, saying that no, I don't want any rights over this property. Let the other person in whose favor I am giving this, relinquishing my right over the property, let that person enjoy my share too, my right too. So this is one way, Usually when it comes to settlement, we also get into something called the partition deed. All of us know that, right? So there is also something known as a family settlement deed. See, partition again, it is of two ways. Either we can go to the court and get the property partitioned, or we can sit amongst our family members, decide amicably who wants how much share, what to do, because as per Hindu law or whichever law we are, even those children in the womb have a share over the property. So when it comes to family settlement deed, we have to think about all these matters, right? But it is an amicable settlement. So family settlement deed, all the family members sit together and decide how much for each, right? It's equal shares, right? So it depends upon the succession, okay? And then we go to the will. This is another way of transfer. But what is the difference? Whereas we go through the other ways of transfers before death. So the transfer of property occurs before our death. If I am going to be the testator, if I am going to be the person who is writing down the property, okay, in favor of other person, be it relinquishment deed, or be it a gift, or be it a family settlement deed, whatever is the way of transfer, I am going to give it to the other person before my death. But when it comes to will, what happens? Whatever is the transfer of property, it occurs after my death, right? And in will, we can write for both movable property as well as immovable property, same as what we have for all the other deeds and agreements, right? Okay, so now when it comes to will, there is only one person. If you take up gift, there is a donor and donee. If you take up the relinquishment deed, there is the person who is relinquishing it and the person in whose favor it is being relinquished. If you come to family settlement deed, then you have the various parties to the partition deed or the family settlement deed, right? So relinquishment deed, all these, they have specific parties, and each one obviously has more than one party. But when it comes to writing a will, One person is enough. And who is that person? The owner of the property. Right? It can be a co-ownership or it can be a single sole ownership, whatever it is, The person who wants to give his share or the whole of his property can write a will, and after that person's death, the property obviously gets bequeathed. That is, it passes on to the person in whose favor the will is written. Now, when it comes to will, many people have a doubt. Should it be written only in one person's name? Should only one person be the beneficiary? That is a very good question, I would say. Okay? Because will, it is not necessary that you should write it in only one person's name. Or it is not necessary that all the properties should be written only in one person's name, or it should not be that each property requires one will. That's not the case. Right? Whatever are the properties which the person owns, either movable or immovable, everything can be written together in one will. So, one will per owner. That would be the criteria. Okay. Next we go to the gift deed. What is a gift deed? See, if you look at the relinquishment deed, family settlement deed or the gift deed, all these are all voluntary in nature. Okay. There is no money transfer when it comes to among the family members. Will is also the same. There are no money transfers. There is no consideration. It's not like sale or sale agreement or absolute sale deed when you get into a purchase transaction. There is absolutely no consideration here. It's purely voluntary and it is free of charge, if I can mention like that. Okay. So next we go to the gift deed. Gift is again voluntary in nature and it is given out of pure love and affection. But one thing, even if it is given out of pure love and affection, it can be given to a stranger too. That is how you have gift deeds in favor of trusts, charitable trusts. Some people, they just want to give it. So they write a will and they keep an executor there saying that after my death, you please give this property to the trust, charitable trust, or if the person wants to gift it to somebody else. But of course, it will be of a, when it comes to the materialistic point of view, it is quite different. But the gift deed can be written in favor of a charitable trust also. It can be a private trust. Absolutely no problem about that. Okay, but it should be given out of natural love and affection. So obviously, there should be a relationship between the donor and the donee. Right? Any type of relationship other than a business relationship. Okay. And one more thing to be kept in view, when it comes to gift deed, donee, the person in whose favor the gift is being given, that donee should accept the gift. Only then it becomes a valid gift deed. Okay. And all these, relinquishment deed is not revocable. When I say revocable, we cannot revoke it. We cannot take it back. Okay. Once I have relinquished my right over a property, I cannot take back unless I have been pressurized to relinquish my right over the property. So that holds good for almost all the ways of transfer. Where the person has been cheated, the person who is writing down the deed has been cheated. Okay, or he has been put under pressure and thus he writes it. So in that case, it can be revoked. Even if it is a gift deed, it can be revoked. Okay, we'll meet. Thank you.